All right, you have 15 minutes each, and the appellant may reserve up to 5 minutes.
Good morning. May it please the court, my name is Mark Stevenson. I represent the appellants Mark Wiegand and Luann Wiegand. With respect to this case, the trial court misapplied revised code section 2315.21b when it continued the bifurcation of the trial after the appellees both conceded that the Wiegands were entitled to recover compensatory damages from the appellees. 2315.21b is a statute that created a substantive right in derogation of the common law, and it had to be strictly construed pursuant to revised code section 1.11. It also had to be strictly applied. Not only construed and applied, but in both situations it had to be done not to infringe upon the constitutional rights of plaintiffs who request both compensatory damages and punitive damages.
How was this alleged error brought to the court's attention at trial?
The alleged error was objected to on the record. The alleged error was also brought to the court's attention in a motion for a new trial.
So the stipulation I'm trying to see this in the context of the trial. The stipulation takes place and we're in the negligence portion or the compensatory damages portion of the hearing, correct?
The instruction from the court that it was going to do that was immediately before opening statements, yes.
Okay. And so what did counsel say to the court to suggest, this is not something that's appropriate?
I objected, Your Honor.
Okay.
And on the record, the court noted my objection.
Okay.
I also filed a motion for a new trial to vacate those awards because I think that was a primary error in this proceeding. Once defendants from whom both compensatory damages and punitive damages are requested from, once they concede that a plaintiff is entitled to recover compensatory damages from them, there is no right to a bifurcation under the statute. In fact, it would be contrary to the legislative intent. The legislature made it particular that during that initial phase, assuming there was no concession of liability or entitlement to compensatory damages, that only the evidence that related solely to punitive damages will be precluded during the initial stage.
But the legislation doesn't speak to whether there's a stipulation or not. It's whether or not evidence of punitive damages can come in during the compensatory damages stage.
The intent of the legislature was to create an even playing field for those persons who had legitimate interests or legitimate claims to be compensated for injuries or damages, and to avoid what was viewed as frivolous lawsuits that may cause a finder of fact to become inflamed at an early portion of the trial, and perhaps find liability when they may not have found liability. They conceded entitlement to compensatory damages. There was no issue at that point whether there would be an award of compensatory damages.
No, the issue was the amount.
Correct. Correct. And persons who seek or request compensatory damages and punitive damages, and when the defendants dispute liability, clearly have a right to bring forth evidence of misconduct or negligence during the initial stage or the primary stage. treat those persons differently than those who are legitimately injured. And the defendant says, we admit you're entitled to get money, but we don't want the jury to hear about what we did wrong until a second stage of a trial.
Well,
That is a treatment of persons in that class differently, Your Honor.
when you say we don't want the jury to hear about what we did wrong, are we talking about what we did wrong, what we did negligently, or are we talking about actual malice?
Many times it's both. And in this case, I think it was.
And your position is that you should have been able to submit that information during the first part, the compensatory damages.
Correct, Your Honor. In fact, I think there should not have been any bifurcation of the presentation of the evidence after there was a concession that the appellants were entitled to recover compensatory damages. The trial court also erred when it refused to allow Mr. Wiegand to read the testimony of Dr. Barry Greenberg with respect to that injured knee. Dr. Greenberg testified that Mr. Wiegand will absolutely develop post-traumatic arthritis in that right knee, and he will need an artificial knee at a cost of $100,000. The trial court also erred when it allowed persons to testify as to the law of the case. The trial court allowed, I would call them, they're not lawyers, persons to testify as to the law of the case, which in fact allowed a repudiation of the admitted or conceded negligence or misconduct on the part of the appellees. The trial court compounded that error when it refused to grant the motion for a directed verdict that Fabrizi was a private motor carrier for hire. Then it compounded that even further by not instructing the jury on the law with respect to inspections, reports, maintenance, and repairs.
Well, it was a little confusing in reading the brief. I thought I understood that the witnesses that testified on that particular issue were called by your client. Is that correct? As to the Department of, I'm not sure if it was transportation, but as to the standards and so on and so forth, those were your witnesses that testified. And then your position is that even though you called them to testify on those issues, it was really a matter of law that the court should not have listened to them, but should have made the determination as a matter of law.
Yes, Your Honor. The court should not have allowed any questions with respect to what the law of the case was from any witness. That was the province of the court.
Would that be invited error on your part to call those witnesses?
Not by calling a witness. I didn't ask them what the law of the case was. The opposing counsel asked what the law of the case was in their opinion. Your Honor, that would be like putting an officer, an investigating officer on the stand with respect to a crime and allowing that officer to give an opinion as to whether the defendant was guilty of the crime. The appellants did not elicit any testimony from any witness with respect to any investigating officer as to whether the violations of this statute or of this administrative system, administrative code was a violation of the law. The administrative code clearly, I shouldn't say clearly, but the administrative code does say that if Fabrizi was a private motor carrier for hire, any motor vehicle with a gross vehicle weight rating in excess of 10,001 pounds was subject to those administrative regulations or codes. The jury was never told that by the court. The jury only heard testimony from persons that was objected to, that it was their opinion that that was not the law. The court had to tell the jury what the law was, and that was the law. The trial
Counsel,
court,
did you want to save time for rebuttal? You did not mention.
yes,
How much do you want?
at least 5 minutes.
Okay, you're at 5:06 right now.
All right. With respect to, the trial court also did not submit the interrogatories to the jury with respect to the physical deformities and the losses of use of the limbs of Mr. and Mrs. Weigand. The trial court also erred when it denied the motion for a new trial. In addition to the reasons that I've given you, the misconduct of Juror Hamley. She rendered a verdict in the compensatory damage phase, and that verdict was less than the amount recommended by the appellees for compensatory damages. No lost wages were awarded at all, and the total amounts were less than what was recommended by the appellees. I'd like to reserve the balance of my time.
Thank you, counsel.
May it please the court, John Christie on behalf of Fabrizi in this case. I'm going to go backward because I bristle when there's a suggestion that there was any juror misconduct in this case. A juror sat through without knowing that she knew somebody a week of testimony and a week of trial, and the second she realized that she knew somebody who worked for my client, she made the court aware of it during the punitive phase. To suggest that she was so conniving and sneaky that she kept this to herself, sat through a week of trial, and entered a verdict in favor of the plaintiffs for several $100,000, and then came clean rather than deliberate to prevent any further awards against her girlfriend's dad's employer, I think is unfair to that juror and unfair to the system. I would also note, as outlined in the briefs, that there was no request at that time for a mistrial. And once that failure was made, that issue was waived and need not be further addressed. Otherwise, you give a party an opportunity for a wait and see. Hey, if I get the result I want, I'll be quiet, but if not, I'm going to scream and yell and pound on the table. And there's case law as cited in both our brief and the brief of the driver, Mr. Steiskell, that demonstrates that clearly. The facts of the case and the facts are outlined in our brief, and I'm going to try to go quickly to address things. The issue of the bifurcation, counsel is arguing as to negligence being the controlling issue on bifurcation. There are two phases of the trial: compensatory damages and punitive damages. Compensatory damages, as your honors are all aware, are designed to compensate the injured party if and when negligence is proven and or stipulated. Punitive damages are designed to punish the malice of the defendant in circumstances where evidence suggests the same. The purpose of 2315-21B is to avoid inflaming the jury. It doesn't say only as to the negligence, and the case law doesn't say only as to negligence. It says we don't want to inflame the jury and have them potentially increase a verdict, which is clearly what plaintiff is arguing for here, or find negligence where negligence is not there. What fair and just compensation for the plaintiffs is has nothing to do with the malice or lack thereof of any defendant. Compensation for the injuries is what the first phase of the trial was about, and a jury rendered its verdict after considering the evidence that was allowed in by the court. As to the punitive phase, at that point, the plaintiffs are charged with demonstrating that malice took place and that a second award to punish the defense is appropriate. This is not about negligence versus punitive damages. It's about compensation versus punishment. And the statute is very clear. The actual words of the statute, not what may have been discussed prior to it becoming codified law, but the actual statement of the statute, and it is clear, they shall be bifurcated. It doesn't say if negligence is proven later or stipulated later or something else, we can bring it back in. This is about compensating for the injury and punishing for the conduct, and they necessarily have to be bifurcated in order to avoid inflaming the jury and having an inappropriate or inflated award, which is clearly what the plaintiffs are and were hoping for in this case. With respect to Dr. Greenberg's testimony, Dr. Greenberg did not appear on plaintiff's witness list. Dr. Greenberg was not the plaintiff's witness. The plaintiff, in fact, called multiple expert witnesses and multiple medical expert witnesses. As they concede in their brief, none of them gave an opinion as to this knee and this knee surgery. Dr. Greenberg was not examined, cross or otherwise, by anybody on behalf of any of the defendants. He did not appear on any plaintiff witness list. There was no meaningful opportunity to cross-examine him. He was a de facto surprise witness at trial. And the case law demonstrates that absent reasonable notice and reasonable opportunity to cross-examine, and the Bernay case and the Jacket case, both cited in our briefs, demonstrate that. Further, it's a discretionary issue. Similarly to the order of witnesses and the examination of witnesses. The trial judge has, under Rule 611, the right to control his or her courtroom and to control the witnesses that are coming in. It is within the sound discretion of the trial court. There is no evidence of any abuse of discretion, and as noted, the Bernay and Jacket cases clearly demonstrate that he's well within his purview as the judge to make such a decision.
Well, to the point of having your opponent call a witness as if on cross, then the court invites you to examine. What's the nature of your examination?
With respect to Dr. Greenberg, or, well, there was no examination of Dr.
Well,
Greenberg.
actually, yeah, not with respect to him, but just in general.
Well, it was the examination that was conducted at trial of the remaining witnesses during plaintiff's case in chief were just typical examination and as would have been taken at any point in the case. One could argue that they were taken out of order.
Which potentially puts the plaintiff at a disadvantage in that it's the plaintiff's case. The plaintiff is laying out its case, and then typically, once the plaintiff rests, then the defendant has an opportunity to lay out their case, and they can recall those witnesses.
Absolutely, and I agree with you wholeheartedly, and I do believe that Rule 611 gives sole discretion to the trial judge to make those determinations. I would take it a step further and suggest that if a party is trying to keep out facts and evidence that are appropriate in the context of the entire trial, and that information later comes in and they believe it factors into the decision, why does it matter at what point it's coming in? This is not a case that was directed out in defendant's favor.
No, but you're telling, as a former trial judge.
Sure.
And a former trial lawyer, you're telling a story. You're presenting, creating this, you're painting a picture for the jury, and, your artwork gets interrupted.
Well, to the extent that the artwork is fraudulent or inaccurate, should we allow inaccurate or half-out artwork to be presented to the jury, and or does it matter when we point out to the jury the error? At the end of the day, the facts are the facts. Whether they're introduced on Monday or Wednesday, they're still the facts. And the jury has a right to hear them and did hear them and reached its decision. On the issue of the permanency and deformity, we've got two individuals who returned to their jobs with no restrictions whatsoever. There was no loss of limb. There was no loss of any body part. There is some talk of some scarring in areas that are not obvious to the public when one is dressed, but I don't believe that gives rise to physical deformity. I think the reliance on a workers' compensation standard of permanent partial disability is improper, and it was objected to at trial, but yet it was still allowed in, and the jury was able to make a determination as to the extent of the injuries based on the evidence. There is no testimony by any witness that these people had a loss of any limb or the loss of any use of a limb. These are two able-bodied people, including Mark Weigand or Wiegand, who is charged with protecting the safety of students at Oberlin College as a security officer. And I would put it to you that to suggest that the man has a permanent disability and yet we're charging him to care for college kids is a duplicitous argument and a scary thing. If he's in fact disabled, he shouldn't be walking around a campus charged with protecting people. He's fine. He suffered a serious injury. He was compensated with a significant verdict in his favor for those injuries. There is no testimony of permanency, no testimony of disfigurement, and no loss of limb, and I think the trial judge was proper in excluding that information as the matter proceeded. With respect to the regulations, the law does say what it says. Whether or not it is applicable to this vehicle and these circumstances is really the issue, and it was not. There's a laundry list of regulations at the trial court level, and in fact even in some of the briefing before your honors, and those laws are open. Those laws say what they say. The fact of the matter is murder is illegal in the state of Ohio. That doesn't mean that the trial judge has to instruct a civil jury on what murder is just because it is what the law says. The testimony, unrefuted, including by witnesses called by plaintiff's counsel, and by plaintiffs in this case, is that the vehicle in question was not subject to these regulations, that the vehicle in question was not for hire. The company is a for-hire company in the hauling business, and it has a private, not-for-hire vehicle that services their fleet of transportation trucks. The transportation trucks are absolutely covered. Their repair trucks are absolutely not covered. How can I say that so definitively? Well, because the two individuals who the plaintiff called in this, one, their expert, who testified, gee, I don't know what the difference is between for hire and not for hire, and the other individual who they don't want to call an expert, even though they called him, and he's charged with the state of Ohio determining which vehicles he needs to check and which vehicles fall under his purview, said, this vehicle doesn't fall under my jurisdiction because it doesn't meet the criteria that plaintiff's counsel seeks to place on it. Officer Michael is the only witness who is qualified to give any assessment as to whether or not these laws apply. This isn't a question of whether or not they were violated. They were not, because the laws didn't apply. And Officer Michael is charged with the state of Ohio in determining A, whether or not there was a violation and there should be a citation or a charge or what have you, and B, whether or not he has the jurisdiction to do so. There is no testimony by anybody contradicting what he had to say, and that this vehicle did not fall under the code sections that he is charged to enforce. So as you go through issues 4, 5, and 6 of their assignment of error, it's important to realize that there's no testimony there, that there's no evidence that the laws that counsel wants to impose upon Fabrizi are in fact designed to be imposed on Fabrizi, and more specifically on the vehicle involved in this incident. To simply cherry pick laws that are good for you and good for your case is not appropriate. It's what laws actually apply in this setting. And in this instance, these laws did not apply in these settings. That's the testimony, those are the issues. Counsel also, it appears to be suggesting that somehow there's some sort of punitive damage per se if in fact there was a violation of the statute. As he has argued and as we've conceded since day one of the trial, negligence is not an issue, and thus liability on the compensatory is not an issue. The issue is, was there malice, thus giving rise to punitive damage? And he's trying to suggest that if there was a violation of these regulations, which I've already indicated don't even apply, so I think it's a moot point, but even if he could clear that hurdle, the next question would be, is that somehow malice per se automatically entitling somebody to a punitive damage award? And obviously the legislature has not afforded any such finding. There's no case law to support any such finding. A violation of the regulation would simply be further evidence of the negligence up to and until there was a demonstration that there was an act of malice on their part in violating a statute that, again, a regulation that didn't even apply to us based on the testimony that was before the court. So I think when the case is looked at and the evidence is looked at, we had a jury that spent a substantial amount of time listening to the arguments and the facts and the evidence of the parties. Candidly, I think too much evidence and information came in that was irrelevant. There was lots of talk about statutes and violations that had nothing to do with this vehicle, this style of vehicle, and what have you.
Counsel, you're out of time.
Okay, thank you. I appreciate Your Honor's time and patience, and congratulations, Your Honor. Thank you.
You have a little over 4 minutes.
Thank you. The jury was never instructed on the law with respect to examinations, investigations, repairs, maintenance, in any regard whatsoever with respect to this truck or any other truck. Had the court said, ladies and gentlemen, I'm going to instruct you that there were regulations in place, but they only applied to vehicles that were had a gross vehicle weight rating in excess of 24,001 pounds, or they only applied to carriers that were for hire and private. Had there been an error in the instruction, we would have objected to it. But the court didn't instruct the jury in any way whatsoever as to the law. The court, in essence, did not, first of all, the court granted a motion to eliminate that it would not allow anyone to testify as to the applicable law. Secondly, the court then allowed lay witnesses to testify as to what the law was and whether it was violated. And then thirdly, the court didn't give the jury the law, even its own perception or understanding of what the court thought the law was. With respect to the regulations are very, very, very confusing, I understand. But it is clear, and it has not been repudiated by the appellees, that if this was a private motor carrier for hire, and it was undisputed that it was a private motor carrier for hire, and if the gross vehicle weight rating of this vehicle was in excess of 10,001 pounds, and it was, they were subject to the regulations, and they consciously ignored them. They were told twice by the PUCO, you're ignoring them. With respect to the cross-examination or the examination of the witnesses that were called as if upon cross-examination during the plaintiff's case in chief, the appellant cite evidence rule 611. That's an evidence rule. It's not a rule of procedure. Procedure in our court, in our system, allows the plaintiff to call an opposing party as if upon cross-examination during his or her case. Simple as that. It's been done for well over 160 years. The evidence rule doesn't change that. With respect to the request for a mistrial. The mistrial with respect to the compensatory damage phase, that jury had already returned its verdict after Ms. Hamley disclosed that she knew the person in charge of maintenance for Fabrizi with respect to the deformities. There was uncontroverted testimony that Mr. Wiegand has a severely deformed left shoulder and arm. He has a 25% loss of use of that arm. That's his main arm. He's a left-handed gentleman. The jury should have been given an interrogatory as requested pursuant to OJI to consider that when awarding compensatory damages to the Wiegands, both Mr. and Mrs. Wiegand. With respect to Dr. Greenberg not being on the appellant's witness list, he was the appellee's independent medical examiner. He wasn't made available to the Wiegands until less than a few days before trial. And then I was told to go and appear for his videotape testimony within 5 or 6, I think it was a week before trial. And everyone was there, Dr. Greenberg, myself, counsel for the appellees. Oh, we forgot to call a court reporter. We forgot.
Counsel, you're out of time.
Thank you.
Thank you both for your presentations to the court. The court will take the matter under advisement and will issue a written opinion that will be sent to both sides, as well as releasing it to our website, Mr.